Hussein's book is specifically aimed at drafting of legal documents for court processes to start, but I think it's not a bad thing to have. And I'm not advertising for him. I've seen the book, I've used it, or I referred to it, and it can be pretty handy if you starting up your career. Another book is also the one for AMLS that you will also find on the LexisNexis bookstore or in any shop that is connected to LexisNexis for selling of books. So that is where you guys can find the necessary things. But in order to draft proper sound contracts, you need to also have the basic understanding of risk. And when we talk about risk, we talk about compliance. That we talk about value added tax as well as tax. So guys, and when you draft, try and stay clear of drafting fancy or use fancy jargon in your contracts. Try and use clear, concise English that will help you to get to the point. So, and also make sure that you use familiar, common contractual terms. I know sometimes we try to sound elaborate, fancy, and funny, or not funny, let me not say funny, clever, then we would use Latin terms in our contracts to look like we are doing our jobs. But guys, sometimes that can also create ambiguity, and maybe it's better to just look at the simple and basic English that you can actually include in the contract. So know your legal principles when it comes to drafting, and obviously you need to know, am I drafting an employment contract? Is this a service level agreement? Whatever type of agreement it is, do I understand the applicable law that governs this? And if I'm going to sort of have enter into a contract where I become one of these people that swaps the coal for stone and then take it to ESCOM, please make sure that your contract is in order, and please make sure that you deliver the right thing. Otherwise, ESCOM will sue you or your client if you are in breach of the agreement. Then, obviously, as any other problem, apply your knowledge to the question at hand. What is the relationship that you want to regulate between you and the other party? And obviously, once you've drafted your contract, please send it to a peer for review. Don't keep it to yourself, because we tend to think we are the best drafters and we've covered all angles, just to come back and see, but we've missed out something. So that is what you guys need to do. On the learning outcomes, I will not go into the learning outcomes. You guys will need to check and see what is the learning outcomes, but I will try and cover the learning outcomes in the content. So in the next 2 days, or today and tomorrow, I'll cover those ones, and then I think also tomorrow I need to touch on legal costs and then move to Wednesday with legal costs if I have my time schedules correct with you guys. Um, but I will speak to Mascala just to make 100% sure that you guys get the right information. Now, generally speaking, when we talk about contracts, the basic concept of law of contract is that there's a set of rules that governs various contracts. Now, the law of contract forms part of the law of obligation. So, but with all um, benefits that you derive from a contract comes certain obligations. So it means that I need to fulfill something, a obligation, in order to get a benefit out of a contract. You cannot just take the benefits out of contracts. That is normally what some people do when they negotiate with government. They want to take out the benefits of contracts and not render the actual service. And then we have these substandard services that is rendered to government, and that's where it comes. Now, there is the concept of obligation comes from Latin, but I mean, I'm not going to tell you guys about the Latin. It just means an obligation means that there's something that binds you that you have to perform. The obligation binds you in a way that you have to perform certain duties. Now, agreement is a more broader term that parties has reached consensus pertaining to some arrangement, and there is now a meeting of the mind. So a mutual understanding that this is what we need to do. And some contracts is then subject to the Consumer Protection Act or the National Credit Act. Because some agreements is like you conclude maybe you go and buy yourself a new, you are just qualified from law school. Now, your first thing that you think, as the young guys all do, I need to go buy myself a BMW. So that finance agreement that you enter into is an agreement, and then it's also subject to the National Credit Act. And you need to take cognizance of the type of agreement or contract that you enter into, what pieces of legislation kicks in. And obviously, the Consumer Protection Act also defines what is an agreement. So an agreement entered to between parties with creating legal enforceable obligations, vice versa. So there will be an obligation when you enter into the finance agreement with the bank to finance your vehicle, is that they will give you the money so that you can buy the vehicle from the dealer. And in turn, you will have an obligation to monthly satisfy that debt plus interest and other additional costs that is set out in the agreement, and parties will then sign the agreement, and based on that, you guys will then have now concluded a contract or a binding agreement between the parties. Now, sometimes contracts may be void because contracts, for a contract to be legally binding on parties, from the start of the signing of the contract, there must be certain things that is in a contract. And if those things are not considered, the contract is then invalid even from the start. And you get those ones. It's like maybe to say that maybe, and let's use a marriage. You enter into marriage at the beginning thinking that the husband or the wife that you are marrying is mentally sound, only to find out 3 months down the line, this person is not mentally, doesn't have the mental capacity to even conclude or enter into agreements, then that marriage is void ab initio from the get-go. So obviously also there is contracts, and the most common one is from KwaZulu-Natal, where you have what they call the Inkabis. The Inkabis enter into contracts with people to kill other people. Is that valid contracts? Can the owner of the contract actually enforce it against the Nkabi if the Nkabi turns around and say, I don't want to go through with a contract? No, because it's unlawful. It constitutes a void contract because you cannot contract to do something illegal. And this can now be in various areas. So if I don't have the mental capacity to contract, then I'm mentally incompetent to contract, and obviously all my actions is then void. And obviously, if the other party who relies on the contract can prove that when I concluded the agreement, my mental capacity was still 100%. It is only afterwards that I lost my mental capacity and became mentally incompetent, then that contract can be valid. But it's like the owner's resident when the person wants to rely on the contract. So a contract is then voidable. It is or one can say it's voidable. It can be declared invalid by one of the parties for a certain reason. Now, also normally signing of wills, it's also like a person's will, and then you might get where people forge signatures of people because they knew how a testator would sign. Then they recall his previous will and then make a new will where they get everything. Then these are also contracts or wills that can be declared voidable or invalid when you approach court. I see Sipo Simon CB. Did you have a question, or was it just a foot fault of the mic there? So termination of contracts, then also contracts, there is unilateral acts where you can actually terminate contracts, but you can terminate a contract legally before the end of a contract or between the expiration before the expiration period, given that you meet certain requirements. Now, sometimes contracts may contain a termination clause, and that would normally be found in that clause that deals with breach. If you in breach of the contract and that one party gives you opportunity to remedy the breach and somehow you fail to remedy the breach, then the other party can elect to terminate the contract and then ask for restitution. So that is then based on damages. So you don't rely on the contract, but you rely on the damages that you've suffered as a result of the breach that occurred by the other party. So you terminate. Maybe it was a contract where they had to deliver certain services and you've paid them, so you terminate. Then you are only responsible pro rata to pay them for the services that they've rendered, especially if the services was rendered correctly. But if the services was also not as per the service level agreement, then you can take it a little bit further. So termination of contracts can either be drawn from the general principles of contract law, or it might arise from the contract terms itself, where you in the breach clause you deal with termination as well as cancellation. Say, for instance, cancellation, you can cancel a contract if another party does 1, 2, 3. It allows you to do so. So when there's non-performance, then you can also rely on cancellation. So cancellation is you cancel, which means you make an election to cancel the contract, so you don't rely on the contractual terms. Now you will look at restitutional terms to say that I want to be placed in the position as if this contract never came to life. So that is what we do when we deal with termination. Now, what makes a contract a valid contract? There's a couple of things that one needs to look at, and obviously, in terms of your readers, there is like, I think, 15 things that one has to consider when you actually dealing with contracts. But first, parties need to reach consensus. So that meeting of the minds should be there to say that we are at idem, we are on the same page as to the agreement or what we want to agree upon and what we want to do for one another. What we say, this will be my obligations, and the other one say, this will be my obligations, and this is the benefit I will derive from the contract, and this is the benefits that I will derive from contracts. Now, parties need to have contractual capacity, and there are certain formalities that you need to meet in terms of certain contracts. And I mean, if you sell immovable property, we know one of the formalities for the alienation of land is that such contracts must be in writing. If it's not in writing, you might have a problem to actually enforce it. And then you'll have to go to the next available remedy to say that, okay, I cannot enforce this contract. I must now look at enrichment claims to get my money back. And obviously, a contract must be valid. As I said earlier, when you now contract to commit or to do something that's illegal, and it can be as simple as this, it doesn't need to be committing of crimes. I know with the RDP housing scheme in South Africa, it is that if you are granted an RDP house, you cannot sell that house in terms of the Housing Act and some provincial regulations before a period of 9 years has elapsed. Now, a lot of people get RDP housing, they sell it, and then they go and build a new shack to try and get a second house. So they make this as a money-making scheme. So this can be done in various ways, and it can be used as a way of actually making money out of government free of charge. So this is what happens, and then one would now have to say, okay, is this legal? No, it's not legal because the Housing Act says that what you need to do once you want to sell a property that's not older than 9 years and not for 9 years registered in your name, you need to then offer this back to the provincial or national government, and they will then buy the property back at a sort of municipal value, and then you get your money, and that's it, and then you won't ever qualify for housing again. So that can also be seen as validity of a contract. So once you enter into an agreement with another person and not offering that property, that contract is no longer legal. So certain aspects of the contract or the content of the contract must be determinable. So you need to know clear. It must clear what this contract is about. So when one looks at commercial contracts, so this contract normally has bearing on commerce. So it's like I give a certain service or good, and you pay me, you remunerate me. But remuneration can also take the form of other service or other good. And that's what we traded long before the arrival of Roman and Roman Dutch law in South Africa. But obviously, we've now just used now money as some sort of an exchange mechanism. But technically, money doesn't really hold any value. It is most probably the commodities that holds value. Now there are various contracts that's relevant to the world of business transactions, and such contracts can be like you get your maybe an anti-nuptial agreement can be one of those ones. There can also be service level agreements, also employment agreements, and the likes can form part of these commercial agreements where there's like a commercial benefit. Because obviously, if you enter into a even a contract of articles with your principal, then there's also some form of remuneration that comes with you are supposed to assist him or her in furtherance of his or her practice. But one of the benefits that you derive from that contract is you get some sort of a remuneration, as well as you need to get training that will equip you to become a legal practitioner. So the terms of an agreement should naturally be set out, and it should be embodied in a contract. Now, in order for a contract to have life, there are certain things that needs to be in that contract. And as we were taught in our days in school, and I think you guys should have been trained the same, there's what we call the essentialia of a contract, naturalia, and incidentalia. And then you have like express and implied terms. Now, the essentialia of a contract, what is that? It is the terms that is needed for a contract for a basic contract to exist. So if you don't have essentialia, it means essentialia, just like the name says, it says essential terms. If that essential terms is not there, then it means that you don't have a valid agreement. Then we have what we call naturalia. Now these are sort of standard norms or terms that automatically applies to specific types of contracts unless you guys or parties in the contract as explicitly exclude certain things like passing of risk. Say, for instance, if it's a logistics contract, you say now the risk pass when I deliver the thing on dock. So that's what we talk about FOB. And that's what it is. So it goes like that. So it's automatically to specific contracts that you say, okay, the moment I put my fruit and veg on the ship, the risk pass from me to the ship owner, the transporter, for the safe custody of until it arrives on the port on the other side. So free on board. So that type of things, it's natural, but you can also regulate it in your contract. So the passing of risk and incidentalia is also one of the terms other than essentialia. catered for by the naturalia of a specific contract. So that is how you look at incidentalia. So incidentalia is normally conditions that you set in motion in addition to the essential terms, and that speaks to like things like guarantees, warranties, time clauses that you can have involved. So you say that, okay, I undertake to do X, Y, and Z for you in terms of this contract or warranty. And warranty, we know like the motor industry would give you like warranty on your gearbox to say that we guarantee that the gearbox will not break in so many years, and then you perform with that gearbox the service provider and get your money back. So that's how it is. Okay.
We are breaking, sir.
So your connection is mute or it's bad.
I think it's low shading. He said something about electricity going at 6 o'clock, so I think it might be that.
Hlakanipo September, can you hear me? I see your hand is up. You can ask your question.
But it's a bit relevant to everything. I just wanted to ask about the RDPs. Like, can you rent out RDP if you don't, if you have?
Yes, you may rent out your RDP, but you may not transfer ownership of the RDP within that 9-year period. If you go look at the Housing Act, that's right. But renting out, there's nothing that they say about renting out.
And you would need a contract to rent it out with your tenants.
Yeah, you need a contract, and that's now the lease agreement. Then the lease agreement, you need to have essentialia in that contract, and obviously from that contract, based on there will be naturalia coming out, and there you can also have incidentalia, where you say that a condition, one of the conditions is that maybe you have to paint the house every 6 months for you to actually be a tenant there, to keep it in good working condition. Then you guarantee, like maybe to say that the roof won't leak irrespective of how hard it would rain, and those type of things, warranties you can build in. So it just depends on the type of contract, and then also the time clauses needs to be in that contract as well. So it's all of these things. So essentialia and naturalia flows naturally from the contract. Incidentalia is also and intentionally and specifically included to say that this is what is going to regulate our contract or our agreement. You need to do X, Y, and Z, and then also the rent will increase every January by 5 or 10%. So that's how we operate these things. And then obviously all contracts that you conclude will somehow be affected by the Constitution as to does it meet constitutional master? Am I not being asked to do something that's against the Constitution and going forth? So there must be some level of fairness into your contracts. So whether a clause itself is reasonable or not it must also sort of take cognizance of the Constitution, and also if a contract can be enforced under the circumstances. So that is all things, but I think in your readers, you guys have enough to read on the constitutional aspects, because there's a lot of cases that deals specifically with those type of things. Now, specific contracts is geared and designed to actually mitigate the risk for parties. So that's one of the hallmarks of a good contract, that you mitigate the risk involved for your client, or not just the risk, but also anticipated risk that may come along. And that's why you would then enter into a contract, be it insurance contract, to say, okay, I know that a ship can maybe sink, or there can be a storm at sea, and it's not viable for me to actually transport fruit from Africa to Europe via a plane, because it will cost too much, and then I won't get my return on investment. So I'm going to send it with a boat. But now I enter into an insurance contract. I also entered into a service level agreement with the boat company to say that they will keep the fruit in freezers in specifically designed containers at a specific temperature, so that it preserves the shelf life of the fruit, and you take it from there. And then you'll also enter into insurance contracts to say that in case there is certain things that happens on the ship, I will be protected. Because once I had a client, he bought himself a Ferrari in Europe, and it was cheap. And then instead of putting it on a plane, he then opted to put it on a ship. And on the ship, you had two options. You can either put the car into a container, then you pay extra money, or you can have the car on the deck of the ship. So he did his research and said, but we didn't have storms and stuff, and we never had ships transporting vehicles sink. And he opted to have the car on the open deck of the ship. Obviously, it's tied up properly and it's standing there with a little sail over it to just cover for the sun and everything. And you guys can imagine what happened, man. That ship then hit a storm, and there was like huge waves that hit over the deck of the ship, and the car was literally underwater, and the entire electronics of the car was messed up, and client did not have insurance for the car. So you can just imagine, then it's like as good as a wreck when it gets here, because the amount of work that needs to be done on the car is then far exceeding sometimes the value to restore it in a good quality condition. But obviously, so when you negotiate your contracts, you need to make sure you need to look at risk, anticipated risk, and risk can be various things that you need to look at. And obviously, what we also call vis maya. So you need to also make provision for vis maya, that you can actually have it there. And in South Africa, the one as biggest risk that we always have to take with our valuable items, it's theft and destruction. Theft and destruction, that borrowing without consent is the nice word for theft. But I think in your readers, you need to also check some of the other things that is mentioned there, that you can actually attend to make sure you meet the necessary requirements, or you take out the right, or you conclude the right contracts, be it for insurance, be it for risk and damage mitigation. You will then have to choose the right one. So that is what you have to look at, and that is what you have to take into consideration when concluding a contract. So that is more or less what you're going to look at. And then obviously there's also tax implications. Tax implications means specifically when you conclude contracts, you need to check how will it affect me on taxes, duties, and levies. So there's different rates charged at different things. So I can conclude maybe a contract that will make me earn maybe 5 or 10 million rand per month, but then I will be also charged at a different rate. Different duties will be applicable to me, and levies will be charged. So maybe if I break it up into smaller agreements, it might be less that I'm paying on tax, but obviously more administration or more balls to keep in the air. So significant amounts of money can be saved by restructuring your transactions in a tax efficient manner. So if you are not knowledgeable, then get a tax consultant or a tax practitioner to just advise you on the tax aspect that might affect your contract. But I'm not saying all contracts is subject to tax. Some contracts, like an employment contract, will not be subject to tax. You'll just need to pay some sort of skills levy and unemployment insurance to the labor department on behalf of the person that's employed by you. And that's statutory amounts, and you can deduct it, but you have to pay it over. Then also, when you're dealing with your contracts, make sure that you take note of trade usages and good business practices. Now, it's always good that you, if you're going to work in the field of contract law and specific contracts, and it can be maritime law, it can be aviation law, it can be insurance law, it can be mining law. Make sure that you have good understanding and sound knowledge of the environment that you're going to work in, so that you make sure you take in consideration all the legislative and statutory requirements that needs to be met in order for a contract to be legally binding and enforceable. Doesn't help you write a beautiful contract on papers, but you cannot enforce the contract. That will then create certain problems for you. Now, the Consumer Protection Act, and I also mentioned in the same vein, the National Credit Act, but the Consumer Protection Act sets out certain things that there was earlier legislation where consumers were protected, or consumer rights were protected. And one of them is like the Alienation of Land Act, Civil Unions Act, Share Blocks Act, National Health Act, Rental Housing. And the Rental Housing Act it speaks to the question that September asked earlier. And Nhlakanipo, September asked, how do you go about it? So the Rental Housing Act will also stipulate what's the responsibilities of a landlord and a tenant. So in terms of our common law contracts were generally enforceable, subject to certain qualification, and it should not be against the mores of the society. So it means that it must be aligning with the moral values of our society. Somehow this approach was like one-sided in favor of the service or product providers to the detriment of consumers, and that's why we have now this over elaborate Consumer Protection Act 68 of 2008, where it set out what is the CPA takes contractual rights of consumers to new levels. So it gives you a little bit more of a buffer as a consumer. And this is like there was an old case that also you could somehow sort of have stifled the service providers free reign, where they could actually sort of limit the consumer's protection, was the Chevron case. We used to call it the Chevron straight jacket, that also companies was in there. So that Chevron straight jacket was also somehow limited due to public policy, and it was later endorsed of some of the contracts. So when drafting a contract, you need to be cognizant of the Bill of Rights, and to make sure that it will pass a constitutional challenge and scrutiny. So that is the same for wills. When you're drafting wills, then obviously the Consumer Protection Act came into being in 2010, and then the remainder of the act, there were certain sections, chapter 1 commenced in 2010, the remainder of the act started in 2011, but it still seems like it was just yesterday, and people are still very much not informed of what they can, should, and can expect of service providers or product providers when they enter into certain agreements. So I think a little bit more of education is needed And then also you have like the Competition Act that works with the Consumer Act in a free market system to protect consumers from uncompetitive behavior. And this can easily be where you as a lawyer start a firm opposite your opponent or competitor. You start a law firm on the other side of the street corner, and you guys have got the same experience level, say 10 years admitted as attorneys, and he charges 3,000 rand per hour for a consultation, and you say, okay, I'm going to undercut him by 50%, and you charge 1,500 rand for the very same hour of consultation. So obviously, you know that parties will then come to you instead of the opponent. Now, that is all that one is to check when dealing with protecting a consumer's right or consumer's right when drafting wills. So you need to make sure you take cognizance of the Consumer Protection Act, the Competition Act, as well as the protection of personal information, that you don't divulge your client's personal information or personal information of consumers in drafting of wills or dispatch it to other parties without the consent of your client to other parties, because this will be regarded as unlawful. Now, legal practitioners, we have a duty to act diligently and professionally at all times, and this is also in drafting of contracts. So in drafting a contract, it is the responsibility of the legal practitioner or the candidate legal practitioner to make sure that the contract is done with due diligence, and it should not contain possible risk. And that's why I said also make sure that you get the thing peer reviewed, because if there's incorrect information or something that is recorded or captured incorrectly in a contract, like the intention of one of the parties or both parties, can lead to disputes and costly litigation. So this is important, that you also take due care when drafting contracts, and especially with contracts, although parties were sitting together at a negotiating table and negotiating certain terms, that oral discussion that was had at that table is not necessarily captured in an agreement. Then or if it's not necessarily captured in the agreement, it can also lead to problems. So make sure when you deal with these types of contracts that you capture everything properly in there. In your readers also you have, and I think Christie's book on law of contract in South Africa, the 4th edition, I think, it speaks to these types of things, the duties of legal practitioners, and it also discusses a case where you can actually see how these things should be how is it summarized, that you make sure you take due care, that you make sure the intentions of parties is reflected in the drafting of your contract. Because obviously where there's no oral or other evidence available or can be used to prove the content of a contract, so the parallel evidence rule then is now not available to us, and then obviously you'll have problems, and this can lead to long and protracted litigation. So when drafting a contract, you need to at least meet certain requirements. Make sure that you analyze and set out what is the party's intention. What do they want to achieve by this contract? Make it clear, and make sure that the rights and duties that emanate from that contract is not just clear, it's enforceable against the other party. So you need to advise your client on the nature and content of these rights. So your client must be fully informed of what rights and obligations he or she derives or gets from these contracts. Thereafter, make sure you go do research to see what does the common law says about this contract, what statutory requirements do I need to meet, what statutory observations I need to also bring in, and also look at what restrictions is there in terms of common law and statute and the constitution, because we need to look at our primary sources of law as to what happens. And then you can just do yourself a favor, look at case law also, where these types of contracts has been dealt with, where the court would set out, this is what should be in a contract for this. Because, I mean, our courts of law has dealt extensively with all sorts of contracts, all sorts of matters already. We've got a great volume of law matter available. So we just need to look in the right places. And guys, contracts should be practical. If your contract is not practical, it will give rise to certain interpretations that does not align or accord with the intention of the parties. And this may hinder or put a sort of a spanner in the works when it comes to performance, because people will then read what they should be doing, what the obligations and duties is in terms of the contract, different. So when we draft contracts, we need to make sure we avert this misinterpretation of things, because things is not practical and it's not clear, so that we avoid unnecessary litigation and disputes, which can be costly for your client. As legal practitioners, we're supposed to always act in the best interest of our clients. September? September, I see your hand is
Yes.
up.
I wanted to ask about the verbal parts of the agreements. Let's say a client comes in and say that we agreed to this and this and this verbally, but then we also signed a contract. Now, the verbal parts, can they be enforced in any way?
Yes. Remember, a contract is binding, be it verbal or written. It will just now be that if the party breaches the verbal parts of the agreement according to you, you will have to then place them in mora to say, listen, yeah, you have breached 1, 2, 3, and I need you now to remedy the breach. If not, then you'll have to now sue that party to actually fulfill that part of the contract that was orally, and then you need to set out the material terms of that agreement. So then it will now lead to litigation, because it's now a he said story. So that's where you need to check and make sure where it is. But I would think it's very, very dangerous for people to actually have a partially written, partially oral agreement. But I'm not saying that these things does not happen. It happens that people will have the initial agreement, then somehow along the line they verbally amend the terms of the agreement without recording it in writing, and that you should advise your client against at all times and warn them at all times, because it may become a prickly pear and an issue or a bone of contention. So that is where you need, but it is enforceable. You just need to then prove the material terms and that you fulfilled all the obligations that arise from that verbal part, and the other party has failed to meet his or her contractual obligations in terms of the verbal part of the agreement, then you should be fine. I hope I've answered you, September.
Okay, thank you. Yes.
Fourthly, one of the things that parties also needs to look at is like, people, when you conclude contracts, if a person who's uninformed about the subject field, if they read it without difficulty and understand what that contract says, then you know you've got a good contract. So I always measure it at that. If I deal with a contract, I would give it to somebody who's my peer, but not necessarily my peer in the legal field, to read it. And if that person say, oh, I do understand and grasp what A must do and what B must do, and what is the benefits for A and what's the benefits for B, without having understanding of the law, then I know I've done my dues in actually making sure that everything is in order in the contract. So that is what you would do as a legal practitioner. But obviously, when drafting a contract, you need to also have capacity. So if you don't have mental capacity to actually comprehend the legal acts that you are performing, then it means that contract will be voidable. So it's now the party that needs to come and who wants to fight a contract that needs to show that at the time when you concluded the contract, you did not have the capacity to contract. Also, minors cannot contract by themselves, so you would get a curator appointed for them to act. But we know that certain minors can be emancipated to actually conclude agreements, that is minors that has the consent of their parents to enter into marriage. Because remember, I said to you guys, marriage is also a contract. So minors, in terms of the Children's Act, they will then have certain rights and obligations that they can actually enter into and actually I don't know now what's happening. Let's see quickly right now before the data kills us and we're already in the dark. So guys, just give me a second. I'm just trying to sort of get ourselves a little bit more of lightning, because now one of the lights just went south here. But minus in terms of a child becomes a major at the age of 18. Back then in South Africa, it was age of majority was 21, but obviously if a minor can get emancipated in terms of the adult. So some agreements may not be entered into with minors, and it's like employment agreements. The Basic Conditions of Employment Act. Employing a child younger than 15 years of age is a criminal offense. The National Credit Act also has like specific things included if you look at certain sections of it. So unemancipated minor can only enter into certain agreements if assisted by a curator. If a person is unemancipated, it's mentally unfit, or a person is on administration. And now I can tell you guys a nice story here is that we know that the mayor, that Makwarela guy, that was the mayor, that was the former speaker of the Tshwane Metro. He was a person that was under administration because there was insolvency. He was declared insolvent and he did not declare, so he was working as a speaker in parliament, and then he was appointed as the mayor, and somehow he then was found out, which means that he did not have the capacity to act in those positions due to him being a person under administration. And then he's now being sued for monies that he earned as a speaker and a mayor. So obviously, if you are found wanting on that front, then you cannot act. So people who don't have capacity cannot then enter into legitimate contracts. And that is now the other party. If he or she did not know that this person doesn't have contractual capacity, the contract is not void from the beginning, but the contract is then voidable. So that is where one is. And there's people that's also now under debt review, debt consolidation. They can then also be sort of half excluded from certain credit agreements because they are under debt consolidation. So one is to check, and that you can find in section 88 of the Debt Counseling Act. So that is where you would find certain things. And as I said, section 88 of the National Credit Act. I was now reading already ahead here. But so that is what one needs to look at when dealing with these things. And then obviously, the Consumer Protection Act has similar provisions to the NCA pertaining to persons lacking legal capacity. So if you look at Section 39 of the Consumer Protection Act, you can then see the similarities with Section 89, read together with Section 88 of the National Credit Act. Now, obviously, you have now this fancy word that everybody is talking about, business rescue practitioners. Now, a company, and we know that SAA was that company that's currently under business rescue. Sometimes we don't know where they are. And it's normally companies that is placed under business rescue, but you can also place a person under business rescue. So that is also a process that needs to unfold, and you can find it in Section 131. So business, and if a person is placed under business rescue, principal debtors can normally ask that this not be done because they will be negatively affected, and then they won't necessarily get their money. Now, people married in community of property, that is as old as it can get, is also somehow limited into what type of contracts they may and may not enter into. Obviously, you can go and enter into a cell phone contract and also buy a vehicle, but when you start taking on long-term debts like going into buy immovable property, then if you are married in community of property, you know that you need the assistance of your spouse or husband or wife, whichever one it is, to enter into that contract. You cannot conclude a contract of such magnitude without the assistance of your husband or wife. So there is instances where you need, when you are married in community of property, where your capacity to contract is somehow limited. And it's like to do with immovable property normally falls under that one. And also when you look at credit, there's a certain credit agreements that require the consent of both spouses if you are married in community of property to conclude certain loan agreements. Now that you can find in Section 15. Not all loan agreements, short-term loan agreements, some of them you don't need, like a credit card, those type of things, you don't necessarily need the consent of your husband or wife. You can enter into the agreement. So there is that case of Gounder versus Top Spec Investments, where the husband was married into community of property, entered into a loan agreement, and then entered into a separate agreement to secure the loan, which was a mortgage bond, without the consent of his or his wife. So that cannot be. You need the consent of the wife, because there is now significant things that might also affect that person's also contracts of surety is covered under contracts that where if you go into surety, you cannot do that without the consent of your spouse, because your contractual capacity is then limited. Then the people that enter into civil unions, and this came about in 2006. It brought about certain important changes in regards to contractual capacity of unmarried persons. Now, you are unmarried, but if you enter into a civil union, it's a type of union. It provides an opportunity for unmarried couples to formalize their living together arrangement, but it's all on a voluntary basis, and it deals with the consequences. And there the Act sets out who is the people that may enter into these agreements. You need to be 18 years or older.
Mr. Art.
Yes.
Yeah, I'm sorry to interrupt you. I just see that you are going to go a bit further before I ask this question. So
Okay.
on mental capacity, what's the standard test? Because I doubt that it's always the case that you can immediately see that someone doesn't have the capacity mentally to conclude a contract. So some people, it's not immediately obvious, and then they join, whatever agreement that you make, they are party to, and then they agree to whatever terms. But later it's discovered that they were not mentally fit at that point in time. And then secondly, when it comes to issues of depression, also Alzheimer's, I don't know how to pronounce it, but Alzheimer, where someone is a state of forgetfulness, and then they now, later down the line, they say that they're no longer able to perform because they don't remember entering into a contractual agreement with you. So typically, what's the way about those situations?
Now, obviously, if you conclude a contract with a person and you cannot gauge because you're not a psychologist or a doctor to actually diagnose a person, from face value, it looks like this person has contractual capacity to you. That's why I said this contract is not void from the beginning, but it's voidable. So you can say that, okay, this person entered into this agreement. They did not understand and comprehend the legal obligations and duties that stems from this agreement, and hence this agreement is now voidable. So that is what happens. And then obviously there is certain institutions where you then send a person for a 30-day observation to see if they courts that you so I just want to it's like, so in criminal courts we do have like where they would send you to Sterkfontein if you're in Gauteng. In Cape Town, it's like there's also a Valkenburg that's common in the Western Cape where they would send people for psychiatric evaluation to see if they've got mental capacity to comprehend legal acts. So you won't see it necessarily from the beginning, but it will obviously be that maybe afterwards, maybe a curator is appointed for this person, and then they evaluate the person. The court will now say, okay, because obviously the family members of that person or people interested, maybe some board members that's sitting with that person on the board, he's the COO or the CEO, and say, but this person is not right upstairs. He's concluding contracts left, right, and center, but technically he's not in a position to do so. So that would be, you have to then look at medical and scientific evidence to see if that person has mental capacity to contract. Obviously, people like minors, people that is declared insolvent or companies under liquidation, obviously those natural and legal persons won't have the capacity to contractually enter into agreements and actually have binding agreements in place. Then obviously we would move to civil unions. Obviously, I said people of the age of 18, and obviously a similar ceremony like a marriage should be concluded. And I won't go into the requisites of the agreement because in your readers, you'll find how a civil union agreement should look, or where parties is in community of property will describe as follows. It sets out what should be in there and what should not be in the contract. And it sets out the legal consequences of a civil union. So that is where you need to look at. Then Section 13 specifically of the Civil Unions Act specifically governs and guides certain things. Now, obviously, if a person acts on behalf of a company to dispose of assets, Section 112 read with Section 115 can be read together to say, listen, yeah, this is what one needs to look at in order to determine what should be in and out and what can a person dispose of. But before I move into companies, I see that we've been busy for over an hour and 10 minutes, and I know people sometimes we cannot concentrate for that long. It's just humanly not right. So I will give you guys a 10-minute break. I will say 1850. I will give a 10 minutes break till 1850. But also in that break time that you have not listening to me, I want you to answer the following question, and everybody must answer this. What is the there's three types of let me say three types of how can I put it now so without giving you the answer. There's three types of terms, three types of terms that comes out of a contract. But what is the first set of terms that is needed for a basic contract to exist? What is the first set of terms?
Yeah, they're in the car because you're gonna take.
Essentials.
Essential.
Eluria Mary something. I don't know, is it Mary Ann? I see your hand is up. Guys, I don't want you to answer me. I say, what is the first term needed to create a basic contract? There's a set of them. There's three, but I want to know what is the basic term. I want you guys to answer in the chat boxes for me. I see Ilura's hand was up. I don't know if it's now down, Mary Ann. So, and then I will give you guys a break till 1850 to just recap, grab a cup of coffee, and then come and sit again at your desks and push on.
Hi, sir.
Yes.
I want to confirm. I had my hand up, but I don't think you noticed it when it came to the RDP houses.
Yes, you can run.
It says the beneficiary of an RDP house cannot let the property for remuneration or sell their property if they have not owned and lived in the property for at least 8 years. If a person decides to rent out or sell their RDP house before the prescribed 8-year period, as prescribed by the law, I think Section 3 of the Housing Act, they will forfeit such property and the provincial housing department shall be deemed to be the owner of such property. Is that correct?
That is indeed 100% correct. I think September was asking about that, but he spoke about rental. But the problem is why people are sort of half, not really. They get these notices that they cannot rezone and use it for business purposes, but they are allowed somehow to extend. The act is clear to say that you cannot rent it out, you cannot sell it. And in some provinces, it's actually 9 years and not 8 years, where they also have additional year. And that is correct, that it's like that. You're supposed to use it as your primary residence and not as a business. And I've seen a lot of places where people actually rent out and actually run businesses at the RDPs. Then you get these bylaw violation notices, and then you need to appear at the municipal courts for violation of that. And that is what it is. But technically, the law is what it is because you got something free. And if you're not going to use it for residential purposes, you need to offer it back to the provincial government so that they can most probably allocate it to somebody else. But I see that there's also some provision that you sort of have to sell it back to them at a market related price, like more or less the municipal valuation. But
Thank you.
okay. So 10-2, we start again. Okay, let's rock and roll. I see my answers. People has given me weird and wonderful answers about consensus and authority, certainty, legal. Guys, the answer there, it was simple. It's essentialia. I see Tandeka came in last, but not the least. There's a lot of people, and I see people said intentialia. Molemo, I don't know what is intentialia, but it's essentialia. And Renier, it was only the essentialia that I said, what is the three terms of the agreement that gives rise to a basic agreement? It is the. That's just some of the answers that I am looking at, but I've been gauging. I see a lot of people mentioned essentialia. Or most people just mentioned everything. Please repeat the question. Okay, so but that's more or less. It seems that people has the gist of what the essentialia and incidentalia is, and then obviously also when it comes to companies, how you dispose of companies and close corporations. And close corporations, you could register close corporations up until I think around about 2011. You could after that you could just maintain your close corporation, but if it's deregistered, you cannot have further close corporations. And obviously, when you as a party or shareholders or somebody, if you want to dispose of a company's assets, you need to at least have 25% of all the voting rights present as a quorum, and 75% of those present must vote in favor of the disposal. And this is to make sure that you don't act in bad faith and also against the Companies Act. And you need to consider all the obligations and also the requirements and what is set out in the Memorandum of Association, as well as the contract that was lodged with the Registrar of Companies at CIPC. Now, obviously, when companies are there, companies need to file annual tax returns. And when a company is deregistered, then they're no longer responsible to file their tax returns. But say, for instance, if your company is deregistered today, you still have last year's tax season up until this year to actually complete, irrespective if the company is deregistered. Business rescue, we've touched on business rescue. It's mentioned earlier into your notes also. Close corporations, you can only dispose of assets of close corporations if 75% of the members' interest is present and they need to agree to the disposal of assets. Same story as with companies, you need to file annual returns, and on deregistration, you need to then still do the returns for the last financial year up until deregistration. You also have like your voluntary associations. If a party to a contract is a voluntary association, you must first peruse the constitution of that association and satisfy yourself that that association has power to enter into this type of transaction. So it must show that they've got legal standing and that the contract that you guys are concluding is legal. So it means that this association is not excluded by law from entering into these types of contracts, and that the rights and obligation that emanates from these contracts is enforceable. Otherwise, you might have problems. So that is just some of the things that you need to check when concluding contracts, and it slots in with capacity. But here it's capacity of legal persons. Remember, we have people or persons, you have natural persons and you have legal persons. These legal persons is your companies, close corporations, voluntary associations, your NGOs, NPOs. Those are all legal persons like that you go. Then obviously you have others like your government departments. That is also in the sphere. If you enter into a agreement and they stand in, then you have people standing in positions of authority, but one needs to check, does this person have the authority to actually bind this department? So a representative, if a party contracts through a representative, and this can also be where you maybe are appointed as a receiver and liquidator in a estate, or you are appointed as a executor of a deceased estate, or you are appointed as a curator bonus to actually administer the affairs of a person, or if you are a curator ad litem, that you can actually bind the person, him or herself, to juristic or legal acts. So that is what one needs to check at all times, and there's also abundance of case law that speaks to these things. So you need to check if a company's representative is authorized to act to conclude a contract. So if you're going to deal with a representative, make sure that you see the resolution that was taken by the company to actually allow that person to enter into that agreement. At some stage, we had a case where a client wanted to sue the school for renovations done to the school, and this client could only provide us documents that they have actually entered into agreement with the deputy principal of the school. Now, does the deputy principal have authority to enter into contracts on behalf of the school that binds the school, that gives rise to obligations for the school? My simple straight answer is no. In terms of the School Act, the SGB, school governing body, has the authority to bind the school into contractual relationships, and they've got capacity to act on behalf of the school to conclude agreements, and not the deputy principal. So one needs to check, and then you need to know, when is it a natural person, when and what actions can a natural person perform, and then also when is it a legal person, be it a company, close corporation, trust, club, organization, a statutory body, company in terms of the Companies Act, which is normally referred to as a Section 21 company. And I think in your readers, they've created a nice table for you guys, how these things work out. So I'm not going to still venture into that. So when concluding contracts, you need to have certainty. So certainty speaks to the agreement which is concluded between parties must be clearly, concisely drafted, and it must set out with certain terms what is the party's obligations and what duties a party has in terms of the contract that is legally enforceable against that other party. If you fail to have this legal certainty in your contract, you might find that your contract is vague, or either it might not be enforceable. So it might lead that it's also void, where you don't have certain things in the contract, and that can be maybe one of the essential items of a contract is not included in the contract. Say, for instance, the parties is there, the goods or service that is supposed to be delivered is there, but you guys don't have the price for what the goods and services will be delivered for. Then obviously one of the essential items of the contract is not there. There's no certainty what I will be charged for you rendering goods and services to me. Although it's clear who's going to deliver and what is the goods, the price is not there. So that then creates uncertainty, and that contract is then void as a result of the vagueness that occurs, because not all the essentialia is present. So that is just one example. Now there's there are different types of contracts that you are always called upon to draft. Make sure that when you draft these contracts that you know what is the essentialia of all of them. I think in your readers there's like 1, 2, 3, 4, 5, 6, 7, 8, 16, 17 types of agreements that you can draft. Make sure your essentialia is there. Then obviously there will be natural terms that flows from that agreement because of the type of law that you operate in, the type of contract that you are drafting. Obviously, if you know you're drafting a employment contract, it must then meet the basic conditions of Employment Act, the Labor Relations Act, the Employment Equity Act should all be worked into that contract to give certainty as to what we are contracting about. So that is just one of the examples that one can look at. So there is various other forms of contracts that you can draft that you should take cognizance of the types of agreements that should be in there. So a partnership agreement should also make sure that how is profits and losses going to be dealt with, what is the various partners going to bring, how many membership interests or members' interest will I hold if I bring a certain capital investment to the partnership. That is just some of the things that one needs to look at. If there's loan agreements, does it comply with the Consumer Protection Act? Does it comply with the National Credit Act? Is it even something that's enforceable? The interest rate check, the interest rate which is incidental to certain things where people say they charge you prime plus one, and then some people don't know what prime plus one is. It's like prime plus one is you take the current repo rate that's applicable and you find the repo rate on the Reserve Bank's website. You say plus 3.5. That's always in terms of the Prescribed Interest Act, Prescribed Interest Rate Act. The repo rate plus 3.5. So irrespective of what the repo rate is, you'll always use the 3.5. Add on top of that, that will be your interest rate. If they say prime plus one, it will mean then that you work out plus one. So that if you say the current repo rate is approximately, I think it's 7.75. Some of you guys can quickly Google. I know you guys like Google. You can check what's the repo rate now. I think it's 7.75. If it's not that 25 basis points up, it might be another 25. It might be 7. Maybe 7.8 or 7.775. It might be somewhere there plus 3.5. Then you get the interest rate, and then you check what is the prime interest rate, and then you can say now I can negotiate to say no, but I won't pay prime plus 4. I can only go as far as prime plus 2 based on my budget. So those are the incidental things that you can, conditions that you can set into motion in your contracts. Legality, as the name say, it must be lawful. Now there's a lot of cases that you guys can read by yourself where they took the liberty of actually highlighting certain things, but it means that a contract must be lawful. And this speaks again to our thing that I made the example where you now gave an instruction to Inkabi to say, listen, yeah, you need to kill X, Y, and Z. And one of the sensitive topics that is currently that we saw AKA, that they said AKA was shot by Nkabis, they actually got paid a specific amount or alleged a specific amount to actually execute our South African icon. And there they performed an illegal act, and that contract in itself is unlawful. But you might as well find other types of contracts that's also unlawful, where people act in a specific way that is in contrast with the prevailing legislation or the common law or the constitution in our country. For instance, there was a discussion we had earlier today where a husband actually saw his wife mixing the poison. Then she tells her children on TikTok, I love you. And then he films the whole ordeal, how she drinks poison and then she actually dies. Is the husband then now sort of half legal? Now, that is just the frame of legality that one needs to talk at to see, was there a duty on me to perform otherwise, or to perform or not to perform, commissio or missio. So that is the things when you look at legality. For me to do something, is it legal to actually do something in that space? So there's a lot of things, and I think your case law in your book speaks about a lot of different spheres where there's contractual agreements, be it loan agreements, be it service level agreements, that was sort of half breached, and also like maybe where you have people that's busy with uncompetitive behavior, then they settle to pay a fine instead of actually remedying their behavior. Cindy Solo, I see your mic is on. Okay, Cindy So is then automatically going off. So there is also, in terms of sale of land, you need to make sure that you comply with not just the Alienation of Land Act, but also the National Credit Act. And in your readers that you have certain things where you have sale of sectional titles, you still need to meet the Alienation Land, but also the Sectional Title Schemes Act or the Sectional Titles Act. Then transfer of businesses, you need to look at then the Companies Act, as well as the Insolvency Act that is applicable. So legality, so check if I'm working in a specific frame or a specific legal field, or I'm doing business in the insurance sector and I'm drafting insurance contracts, be it for big corporations or is it personalized insurance and not business insurance, do I meet the requirements of the legislation? Now, there are certain things that one needs to check when dealing with certain things. And for instance, if a person is placed, if you now invoke the provisions of the Insolvency Act, you also need to do certain advertisements in the newspapers and the government gazette for that insolvency to be properly performed. So if you fail to do that, it can lead to criminal convictions. So that is just some of the things. Also, the Administration of Estates Act says for you to finalize and wind up an estate properly to be considered binding on all parties and that you've disposed of your fiduciary duty as a executor, you need to advertise the Section 29 notice to the creditors, as well as the Section 35 liquidation and distribution account for creditors to see. So that is just some of the things that you need to take cognizance of. I've already touched on the Labor Relations Act, the Employment Equity Act, and the BCA, and that speaks to your labor relations or labor-related matters, where they also deal with when there's maybe a Section 198, where a company applies for Section 198, that they have to comply with certain statutory requirements as well. So that is just when drafting contracts, you need to always check, am I within the legal framework for that specific area of the law? Am I meeting these things? When you deal with credit agreements, be it leasing, money lending transactions, you know, I need to check the NCA. I need to check the Consumer Protection Act to make sure when drafting these agreements, I meet the necessary thresholds set out in the National Credit Act. Is the National Credit Act even applicable to my type of credit agreement? So you need to know these type of things. You need to know also, where does the Credit Act actually say that this type of agreement is unlawful? So then one needs to also go look at the Consumer Protection Act. What is an agreement? Does this even form an agreement? Is it a short-term agreement? Is it a mid-term agreement? Is it a long-term agreement? How is it affected by the act? And that is all the things that you need to check in to see if this credit agreement, what is it classified as? Is it a credit facility? Is it a credit transaction? Is it a credit guarantee? Is it a short-term credit transaction? Is it an unsecured or a secured credit transaction? So these are all things that you will find from the legislation that govern that field of the law, to make sure that you can enforce and actually incorporate it in the agreement, to make sure that you set certain conditions and terms in that agreement to mitigate or anticipate risk. That's eventually the main purpose why we draft contracts. Nothing more, nothing less. We draft contracts to make sure that we meet our client, or we mitigate our client's potential risk. So all these credit agreements, make sure that when you draft the credit agreements, that it is in plain, simple clearly unambiguous language. Don't be the typical lawyer that try and write in this fancy jargon. You will get sort of half into a pickle because maybe the term that you're using in the specific type of contract that you're drafting has a different meaning, and you might have different outcome or interpretation of certain things. So when I say credit agreements, we need to know what is small credit agreements, what is intermediate credit agreements, and what is large credit agreements. So we know small ones does not exceed 15,000, and then mid-sized ones is between 15 and 200,000. That's what it is. A pawn transaction or a guarantee or a mortgage is never an intermediate transaction. So a mortgage is always a large credit agreement, but you might get where you take out a mortgage, maybe a second mortgage of 30,000 Rand then it's like sort of half. It falls within that bracket of intermediate, but is it an intermediate agreement? A mortgage bond is always a large credit agreement. So a pawn transaction and a guarantee is never large agreements. It can be also small agreements. So that is what one needs to check. Now, there is prescribed formats how a small credit agreement should look like. And this is, again, we run to the forms in the National Credit Act. Then we need to also know what agreements is seen in terms of Section 89. Now, I told you guys earlier, Section 89 read with Section 88 of the National Credit Act speaks to unlawful agreements, and then I think also Section 29 of the Consumer Protection Act. I speak under correction, but I think it's Section 29 that will also say to you that what is unlawful, and then one needs to check now when you have like unemancipated minors, mentally unfit people, or people under administration, they will lack capacity to act. And you get negative marking where credit provider sets up an offer to entice you to enter into a deal just for you to find out after you've concluded the agreement that, but this is not what we agreed upon, and there's additional hidden cost that was not explained to you. So negative marketing is prohibited in terms of Section 74 of the National Credit Act. And then you can obviously go and complain at the Consumer Ombudsman, because to actually trap somebody into a contract, that is unlawful. So there is also certain things, and where and this normally happens a lot, where you get to a place and people make you sign a lot of documents without reading them. So that is also not allowed. It's unlawful where you conclude a credit agreement where the provider includes in the packs of documents signed by the consumer various documents that's not lawful. So this can happen. Then you also have where people is unregistered credit providers. Now, the NCA requires that all people who provides credit must be registered. Now, a credit provider that's not registered and you conclude a credit agreement with that one, it's unlawful unless when you conclude the agreement or within 30 days thereafter, the provider applied for registration and was awaiting the outcome of that application. And there's also case law to that effect. So it's important to then take cognizance of the fact when you draft credit agreements, you need to make sure that is this an agreement that falls in the scope and ambit of the National Credit Act, and is the Consumer Protection Act also applicable. So unlawful credit agreements section determines that various clauses that are unlawful should not be inserted or form part of an agreement. Each agreement must be checked against the provisions of the National Credit Act, and in Section 90 it says exactly what type of agreements is excluded. So you can find it there, and then there is also agreements where you, if you've entered into an agreement which is unlawful, that you forfeit certain things, and so you need to check very clearly and also look at where you most probably enter into agreement, and this happens a lot, where people make you sign credit agreements, and the credit agreement, you sit down in Cape Town, you conclude a credit agreement that gives the court down in, let's say for argument's sake, in Brandfort in the Free State, jurisdiction over your credit agreement. These credit providers know very well that if you are in breach of the agreement and they serve summons on you, they will go and issue summons out of Brandfort Court in Free State, serve it on you in Cape Town, and they know full well you will not travel from Cape Town to Brandfort to oppose that application, that judge, the granting of that order. Then they get the order on a default, and later on they do what they call a CCJ, a certified extract of the judgment, and then they come and enforce the judgment in Cape Town. This happens a lot, and that including of terms relating to jurisdiction, where you consent to jurisdiction, are unlawful. You can look at section 124 of the National Credit Act. And this, when I did my articles, a lot of credit providers did this, and their unscrupulous behavior, because they could see they could milk the system very easily by doing that, because people won't even know where the court in Brandfort sat, where they actually got judgment. So the effect of unlawful agreements and terms is that it is void, and the court must not sever or change the clause itself, because it may be unreasonable with reference to the contract as a whole. So courts can then interfere to say that we can sort of have sever the good from the bad when you have like unlawful terms. But an unlawful agreement by itself, the entire agreement then becomes unlawful. So you can change credit agreements, but it should be by consent. A credit agreement cannot be changed unilaterally, unless unilaterally. If a party changes an agreement unilaterally, that agreement becomes void unless the change reduces the liability of the consumer. If it increases the liability of the consumer, you need both parties to agree. So the credit provider must then get the consent of the consumer. If not, that cannot happen. And then we have something what we call reckless credit. Now this happens a lot, and this happened a lot during the COVID period, where banks was just increasing people's credit limits without checking if the people can actually afford certain services. They were just giving credit to people, credit, and now people are in debt and over indebted, and then they cannot. Now that comes down to reckless lending. Now the credit provider must at all times assess a consumer's ability to service his or her debt before granting that person credit. But then you'll get people that is now unscrupulous, and they will go and mislead the credit providers into giving them credit, and later on they will say, but you did not do due diligence checks to see if I actually qualify for this credit or not, and then they will go down and say, but I cannot. Now courts have for good reason, and with reference to section 81 of the National Credit Act, refused to give credit providers summary judgment when there was some sort of reckless credit, or maybe just some sort of indication that reckless credit was granted. Now, how do one determine? One needs to look at various aspects to see if the National Credit Act applies to your agreement or not. And the court in the Silver Falcon Trading 333 case was very clear on how you would determine whether the NCA is applicable or not. And you can also go to the government website on determination of thresholds, which serves as an example. And I think in your readers, there's also some sort of a indication what you need to look at to say, yes, the NCA applies, or no, it does not apply. And there's a lot of criteria that you have to match. And you guys can look at the flow chart. I think it's on pages 59 of your readers. Now, cost of credit, it's you look at your principal debt, initiation fees, service fees, interest. And here, guys, I said to you guys, interest, you need to look at the repo rate plus 3.5, as well as the agreement between you and the credit provider as to with how many percentage points will they increase the prime rate, to say prime plus 1, prime plus 2, prime plus 3. And obviously, when you deal with some of these credit providers, they will suck the blood or the last little bit of blood out of your body. So you need to acquaint yourself what is the repo rate so that you can determine what is the prime rate and advise your clients accordingly if they should be entering into such credit agreements with these credit providers in a contractual agreement. Now, costs of any credit, there is certain things that one needs to look at. When you have some sort of insurance, there's a cost, and it's normally a little bit high. You also need to check when you actually default on your agreement. What does the agreement that you concluded with the credit provider says? The commercial contract says when you are in default, on what scale costs will be charged, because normally you will have in the agreements what we talked about, attorney-owned client scale. But we know if that credit agreement can be a sort of half enforceable in the magistrate's court, then you know the magistrate's court cannot give an order of attorney-owned client. It can only go up as far as attorney-client. So some instances, the court will also say that the cost that you want to sort of make part of the agreement is not fair and reasonable, and they may not give it to you, but maybe lower that cost. And then obviously some of these agreements will include collection costs that a party needs to pay when they are in default. Now, collection costs means an amount and that you charge for actually collecting installments on behalf of the credit provider. So that in itself is something that you need to check at all times. And obviously, some pieces of the legislation makes provision for these types of costs and how you actually calculate them. In the Magistrates Court Act, there is certain types of thresholds that collection commission can be charged at, but collection costs can also be all reasonable costs that a attorney would be able to recoup from their client. And then it gives you a whole set of definitions. What is credit, default administration charge, initiation fees, principal debt. That is all the definitions that is given to you, service fee, settlement value, and so that you understand how these things work. So there also the interest rate, the National Credit Act sets out and it prescribes the maximum permissible rate. Prior to the national interest rates were imposed in credit agreements were governed by the Usury Act. Now we've got like what we call the prescribed interest rate act. And this is when you look at the South African Reserve Bank repo rate, or they call it the repurchase rate, also known as the repo rate. Now, as I said, if you go look at the prescribed interest rate act, it is giving you a 3.5 value. So you'll say the repo rate plus that 3.5 value, then you can determine the interest rate. So administration charges you'll also find in, but it's also curbed or capped in certain instances where you have maximum initiation fees for mortgage agreements, credit facilities, unsecured credit transactions, as well as development credit agreements. That is normally what you, when you deal with the Industrial Development Corporation and some of these development banks, where you get certain interest rate that is there. So all these things you sort of have captured. And I know in your notes, they don't necessarily refer to the Prescribed Interest Rate Act, but I know it's there, the Prescribed Interest Rate Act, and it helps you to actually determine what the prime interest rate is in a specific or at a specific time when you actually enter in South Africa. So currently it looks like it's 10.5%, but there is like the Prescribed Rate of Interest Act, the prescribed, and that is actually, I cannot type because I'm sort of half using this device. I will so it's the Prescribed Rate of Interest Act that indicates it's 3.5, so it's 3.5 plus the repo rate that you'll find on the Reserve Bank's website. So that is for interest. So then you'll have your collection costs, and the Magistrates Court rules is clear on what it is, and then you also have the Legal Practice Act that stipulates that, and also the Debt Collectors Act. So the amount that you find in the Magistrates Court Act, its collection commission is charged at 410, and on each installment to a maximum of 410. If it matters in terms of section 65 of the Magistrates Court Act, it will be set at 411 rand. I don't know, don't ask me why is there difference between matters, normal collection matters and matters in terms of section, and it's only 1 rand. I don't know what was the intention of the legislature with that. And collection commission in terms of the National Credit Act is set at 435 rand per installment. So we used to have this thing of 10%, but if you pay an installment of maybe let's say for argument's sake 50,000 rand per month, then obviously 10% of that would be 5,000. And then they said, but sometimes the consumer will then be negatively affected, and we need to come in, and that's what they also call the induplum rule. The induplum rule comes from the common law, and it says that it basically limits the interest that a creditor may charge on account that is in arrears. So otherwise, they will charge you interest on interest. But the normal things that will be allowed following amount that may be added cannot exceed the unpaid balance under a credit agreement that occurs when a default occurs. It's the initiation fees, service fees, interest, definitely not cost of credit. So, and there's other charges. So make sure when you also conclude agreement that you take credit insurance in case one of the parties that's supposed to service the debt cannot service the debt due to passing on. Then you have credit life insurance policies for the existence of that credit agreement. So something like that to protect yourself or your client is when you maybe buy a car, and in order to protect the joint estate, you'll also have credit life insurance that in the event of that person passing on, that credit insurance policy must cover all the liabilities of your client in terms of a credit agreement, including the fees and charges in respect of that specific credit agreement. And obviously, you need to also take cognizance of exchange control. Maybe that credit agreement is concluded between you and a company, and you paying that company in dollars or in euros. because you bought something on the other side of the continent, make sure that you also know what the exchange control measures is to perform duly in terms of the contract. Say, for instance, if a South African, you as a South African or your client as a South African needs to make payment to a non-tax tax person to South Africa, and it can be a natural or a legal person. So that is also what you need to check. Also, in contracts, we have a lot of these things that we call restraint of trade. Now, in practice, this is a common occurrence, and there's like many types of deviations or variations of these restraint of trades that is included in agreements, but some of them is like unlawful, because you would now say to a person that you cannot work for another broadcasting company in the next 2 years. If the person is a journalist, how must he earn a living? He or she must then enter into that agreement. So you cannot say to him, he cannot work for another broadcasting company. That's why you guys would see our contractors, or not our contractors, our journalists, which we call the freelance journalists. They can move from ENCA to Newsroom Africa to SABC. It's like a recycling of journalists that one would normally see, because they cannot be limited in how they operate. So many types of these agreements contain restraints which are aimed at protecting the goodwill of a company. Obviously, back then, DSTV tried to pull a stunt with Robert Marawa, where they tried to tell him what to do and how to run his shows. And he said, no, I'm going to leave. And they wanted to throw restraint of trade. And he said, but my name as Robert Marawa is a brand. It's not based on your thing. So mostly these restraint of trade agreements you'll find where there's an employment relationship, sale of business. Obviously, a restraint of trade is sort of half legal. If I buy your business where you were selling maybe hot dogs and chips at the corner of the university, and now I come and I say I want to buy your hot dog and chip roll stand, and with the clientele. So yes, you sell it to me, but 2 weeks later you open another stand on the other side of the corner where you sell also hot dog and chips. That then, with sale of business agreements, you can have that restraint to say that you are not allowed to trade hot dogs and chips forever in this venue because I bought this from you. So restraint of trade provisions should be legal when it's concluded between parties. So sometimes you have where you have estate agents that is signing restraint of trade agreements when they leave, to say that they will not trade in property or sell or buy property in that very same area for which they were agent under another agency. So these things can happen. But where it's now, where this agreement restraint was concluded by where he or she does not have a fidelity fund. Remember, these guys are also subject to certain fidelity fund requirements. Then you can say that agreement, that restraint of trade, becomes unenforceable. So that is just one of the things that one needs to check at all times. When a restraint of trade is implemented, is it enforceable against the other party? Am I even allowed to have such business? Can I say you cannot start a credit providing services if you leave my area in the same area that I'm operating, but I'm not registered with the National Credit Regulator? No, I cannot. That agreement will not be valid, that you force me to stop if I have all the legitimate documentation and you don't. But obviously, we know that a person can still apply post facto to get these credit agreements in place. So that is just some of the things that one needs to look at. when actually dealing with credit agreements. So also concluding contracts, and that speaks to the alienation of land. The person that's actually now alienating the land, especially in instances where they're acting in an official capacity as an executor or trustee or whatever the case may be. If they want to sell property that belongs to to a deceased estate, they must make sure that they comply with all the documents. So they need to make sure that the registration officer must get all the documents related to the sale of the property, and that the master of the court at which the sale of that property is or the deceased estate has been reported does not object to the sale of the property. Especially this can become a problem if you have minor children who has now a legal guardian appointed to them, but the person who is the executor of the estate is not the legal guardian of those people. And if the property is sold, their children will become homeless, then the master might not uh, be amenable to the idea that the children's home be sold unless the executor can prove that the monies will be used to actually, or that there's already plans in action to make sure that the children will not be left homeless and destitute. So trustees can also act on behalf of a trust, and they should be appointed in terms of the Trust Property Control Act. They are afforded certain rights and they have capacity to act only if authorized to do so. So if a trustee is not authorized, so if you're going to enter into an agreement with a trustee, you need to make sure that you double check if the trustee is authorized to do or to conclude certain agreements. Obviously, you will land in hot water if a trustee purports to perform a legal act or he lacks legal capacity to bind the trust. Your claim will then not be enforceable. The contract then will not be enforceable because that act that the trustee performed was not in line with his or her powers afforded to him in terms of the Trust Property Control Act. Now, this also can be seen, and there's case law where the SCA say trustee need to act within the prescribed quorum as well as within the quorum set out in the trust deed. So there's a trust deed is a document that says what can trustees do and not do. So you need to always make sure when you deal with trustees to make sure who is the trustees. Are they aware that this person want to enter into a legal act that will bind the trustees? Because all trust assets are held for the benefit of the beneficiaries. So when a trustee conducts him or herself, he or she acts to perform duties on behalf of the trust. So the business or businesses that the trust own or is part of, that trustee then acts on behalf of that trust. So they need to have the relevant authority. So it is always of importance. And some people will think you don't trust them, but you say, can you just provide me with the authority that you have from the Board of Trustees to enter into these types of agreements? So a trust, on the other hand, is not a juristic person. So in terms of the National Credit Act, if it's not one of, if there's not one, if it has not more than three, if it does not have three or more trustees, then it's not a juristic person. So there is certain things that one needs to check. But in terms of the Companies Act, a trust is then regarded as a juristic person. So if a trustee is less than 3 people, then it's not a juristic person in terms of the SCA. So that you need to check also how many trustees is there in order for you to say, can I enter into a credit agreement, short term, intermediate, or no small, intermediate, or large credit agreements. So that is what needs to come out from your investigation. And obviously, you can then now decide if this is a person or a legal person or a natural person that one can enter into agreements with. So there's various things where you need to check and see if this agreement gives rise to a right, and if the other party will have the right to rescind the transaction due to our non-compliance with the type of agreement or contract that is concluded between parties. So obviously agreements where you have direct marketing in terms of the ECTA Act can also give rise to where consumers can say, I don't want to be part of this agreement because this is direct marketing, and where you've approached to supply goods or services, especially when it's to the detriment of the consumer. So there is then certain things that a consumer may, and a notice of rescission should then be sent to the credit provider or the service provider. And you can then also lay a complaint with the National Credit Regulator or the Ombud to say that my right as a consumer to good quality goods and services was impacted and I did not get it. And the conduct of the credit provider was not fair towards me in that the dealings and the handling of my matter was not fair. There was a lot of false and misleading or deceptive advertising or stories that was told. And we recently had a client where she was phoned by somebody from MTN, and they sort of offered her a iPad, and they offered an iPad on contract for a period of 30 months at 483 rand, and they would load her existing contract that was already 400 rand on top of that. And she asked them explicitly, and we could hear from the conversation, was our client, what our client did, she was actually clever in recording the conversation. She asked them over and over, are you sure I'm just going to pay 483 rand? Are you sure? And the salesperson then was adamant, this is the only amount, and then it will only start in May. And lo and behold, when the invoice came out for her normal MTN account that she has, there on top of that contract was the new thing for the iPad included already in the April invoice. So we quickly jumped on it, and that transaction was rescinded, set aside, because there was a lot of false and deceptive information and representations made by the agent to the client. And then they still wanted to charge the client to deliver the stuff back to Durban. Client said, no, I did not deliver it here. You guys were deceptive, so I'm not going to incur any cent as a result of your deceptive representations or marketing. But that is all the things that you need to be cognizant of and take into consideration when drafting contracts with your client. So also non-compliance with CPA and NCA, depending on what type of agreement you are concluding, is also a solid defense against the enforcement of a right that emanates from a consumer contract. So there is various things that, although it's a complicated mechanism for protecting your rights, but Chapter 3 of the Consumer Protection Act, and you can lay complaints to the Consumer Complaints Commission, the Ombud, and an important question that one needs to is whether there was a contravention of the Act, and that is the same for the NCA. You look at whether there was a contravention of the Act, contravention of the magistrates court or the high court. So that is what one looks at all times. So in such matters, courts must consider the fair value of goods. So when a client feels that, but you said to me, this is what it's going to cost, now you're charging me that, the court will still look at, is it the fair value of the goods and services that were rendered, the nature of the agreement that was concluded, also the conduct of the supplier of the goods or services. Was it open, honest, and fair, transparent? And the language that was used during the conversation with client, especially when you deal with online transactions, was it plain, concise language for the client to understand and not legalese or legal jargon that one needs to check now. So if you now want to say that, okay, the contract, there was a lot of misrepresentation and the contract is void, the court must now look at, can I take that part of the contract or that terms in the agreement that I can see is void because of dishonest, and separate it from the rest of the contract and see if it will render the contract still lawful and enforceable as that, and even is there still a valid contract that exists between the parties. So also we know now a lot of people now enters into business agreements that give rise to certain things. And one of the common things is now where you get your McDonald's, your Chicken Lickens, your KFCs, all these things is franchises. And we know all by now McDonald's main business is not selling burgers. It might look like that, but McDonald's main business is actually leasing property and getting royalties, because they own the premises, then they lease the premises to you, so you pay franchise fees as well as for the lease agreement, and that's where they make their money. So when you look at franchise agreements also, there's certain, you need to know the law of contract, you need to know competition, the Competition Act, you need to know what intellectual property is, trademarks, how you deal with it, and then obviously the CPA will set out definitions, the application of the act. So you need to be well versed with the CPA, and also minimum information requirements set by the cabinet minister responsible for consumer protection as set out in the act. And you look at the regulation, section 7 of the CPA read with regulation 2 of the Consumer Protection Act. That is when you deal with it. Now I see in your readers they've gone the extra mile for you. I think the people drafting the readers was very nice. They set out the regulation, and the regulation is clearly, you need to just read what needs to be in a franchise agreement in order to have it lawfully, or to make it lawfully binding on both parties. So that 100 pages, or it's not 100, I'm just exaggerating, it's from page 84 to page 88, 89 of your readers. It's typically says what the regulation, so it sets out what should be in, so you can draft a comprehensive and clear franchise agreement and make sure that when a franchisee wishes to enforce his or her rights against the franchise, so you know exactly what this regulation is, and then you can go to the National Consumer Tribunal to ensure that you've got locus standi to enforce your rights that arise from the predate of the CPA. And then there's case law. Lease agreements, at least the lease agreement should have the essentialia of a contract, but what also is of paramount importance, one needs to know what the rental housing agreement says. So the relationship between the Constitution, the Rental Housing Act, as well as the Consumer Protection Act, you need to understand how these things work in conjunction with each other. Obviously, if you have a dispute with your landlord, you can then approach the Rental Housing Tribunal to say, come and intervene and resolve this thing. But you are not allowed to withhold the monthly rental. You still need to pay the rent. over to the rental housing tribunal that will keep it in trust until the dispute between you and the owner has been resolved. And then they will pay the monies over to the landlord or the person who's renting out the property to you. And now here the RDP house jumps to mind again. Yes, people do rent out the housing, the RDP housing. Will you be able to go look for relief at the rental housing tribunal? No, because you are not actually entitled to do so. But we know people does rent out their RDP houses, but it's also very difficult to detect this renting out of RDP houses by the authorities. And we can see this by the spaza shops that we find that a lot of Pakistani, Bangladeshi, and Somali guys is running in the township where they rent the houses from people. The people set up another shack somewhere, and then they get maybe 10,000 rand a month for renting out their RDP. And these people pay for all the services that comes to the property, and that is what it is. So property owners let immovable property for residential purposes, and then the Rental Housing Tribunal Acts applies, and then when the disputes arise, it regulates how the relationship should be between tenants and landlords. So lease agreements should contain certain elements that is set out in Section 5 of the Rental Housing Act. But basically, it must say who's the parties, what's the price for the rental, and also where's the property situated. But then also natural things that will come out is who's responsible for the maintenance of the property, who's responsible to pay for the service levies, and then you can have incidental terms there too. Let's say because you're using the property, you need to paint it once a year inside and once every second year outside. If this happens, who's responsible for that type of thing? So all these things is there, and I think in terms of the Rental Housing Act, also they've set out what is in the Rental Housing Act in sections 4, and the section 5 is also put in your readers when it relates to landlords, and it stipulates a landlord must do certain things if requested by a tenant. They must do certain things, and a lease will be deemed to include terms and enforceable in a court if it gives certain things. So you need to make sure that you comply with section 5 subsections 1 to, I think, what is this, 9 of the act, and also it deals with renewal of lease agreements. So this is something specific that you can go and look at as to lease agreements, and this you'll find specifically when you're dealing with property, and also you've dealt with property law in university. But know that every contract starts, there must be essentialia, and based on the essentialia and the type of work that you're doing, be it insurance, medical, construction, engineering, there will be certain legislation that governs how the processes work and what should be on the premises. So like various services, municipal services that should be included. That's natural things that flows from a contract. So if I hire a premises from you for residential purposes, then at least there must be flowing water, electricity, so that I can actually have a dignified living at the premises. So that is what one would necessarily look at. So obviously also in your lease agreements, you'll make sure that you look at instances where the consumers go into default, how you will deal with arrears, should you charge interest, and here you need to look at the National Credit Act to see if this agreement falls within the scope of the National Credit Act. But out of my dealings with the National Credit Act, I know already lease agreements is expressly the lease of immovable property is not credit agreements, and there is case law to that effect. But however, the term lease is defined in terms of section 1 of the NCA. So one needs to check. The Consumer Protection Act also defines rental, and I think these types of things need to be drawn closer to each other so that we get legal certainty. Because they, in terms of the, I think the National Credit Act gives a definition of what is a lease. Then also the NCA, the CPA also gives a definition of what can be a lease, and it excludes to a certain extent a rental agreement. So a lease then in terms of the NCA will not include a rental agreement in terms of the Consumer Protection Act. So that deviation should also be dealt with. And then obviously breaches, you should also deal with breaches to say when and how can I actually deal with breaches of legislation, specifically in the National Credit Act. And then obviously we have a whole host of other things that one can look at to say, listen, yeah, this is now what should be in there. And obviously we know when a lease agreement is on the table, there's also the possibility that you can also now start dealing with evictions. Because if a person is in breach of a lease agreement, you can then apply to court to get him or her evicted. So one can also say in terms of the contract, you can somewhere already make provision for lease agreements, what should be a legal eviction. So you can have a clause in there, and I think in your readers, they sort of have an example of what is there, but this is still a legal process that needs to unfold. You cannot just evict a person. You need to follow what we call the prevention of unlawful eviction of people, also known as PI. You can then go and say, okay, the Prevention of Illegal Eviction from Unlawful Occupation of Land Act, that's actually the proper citation of it. You need to follow certain requirements, and you can then bring an eviction either using an action procedure or a application procedure. Now, where I would normally use action proceedings for evictions is when there's outstanding and arrear rentals. If there's nothing of that sort, I will just use the application, and you need to then make sure you meet the requirements as set out in section 4 of the PI Act. If you don't, then that eviction can be seen as unlawful. So you can also include in your agreement, the lease agreement, under what circumstances and how you will deal with eviction. This process of eviction can also be sort of have derailed or frustrated if you want to start eviction proceedings and your tenant then go approach the rental housing tribunal, then everything that you want to do in terms of PI is sort of halted until the Rental Provision Act, specifically section 5 of the Rental Housing Act, has been adhered to. And then there's also different types of eviction that goes with different types of property, because you'll have like what we call a commercial eviction and a residential eviction. You also have like your ESTA evictions, and you need to make sure that you look into these types of contractual agreements when actually dealing with various types of contracts, specifically lease agreements here. Because obviously, if you don't know what sits in the Rental Housing Act as well as in the Prevention of Illegal Eviction of Unlawful Occupation of Land Act, PI, then you might give your tenant a clear defense for them to hold over or hold on to your property. So you then give them a defense for holding on or holding over your property. But there's also things like what they call a lien that you can actually use, and also when you cede your rights, and that it might affect the locus standi of people to actually institute eviction proceedings. Don't. So when you cede your rights to a specific thing, make sure that it is in accordance with the legislation for which you want to use it. So that is what you need to look at. And then there's a whole lot of acts that you would find when you have labor tenants on your farm. You need to use what we call ESTA. ESTA, and ESTA is also known as the Extension of Security of Tenure Act, which sets out the legal status pertaining to labor tenants being on your property. So lease agreements where farm laborers are tenants, they provide labor in exchange for residence and farming rights or some sort of a remuneration. So that is also, you need to check these types of things. And that is all what you need to check when drafting contracts. So all contracts should meet certain formalities. If you, and let's say for argument's sake, you're dealing with a contract and you don't meet the formalities of that contract, you might have a problem. So if you don't meet the formalities that is set out in legislation, you can then not enforce that contract. And one of them we've touched already on is like where you deal with alienation of land, also where you try and acquire share blocks in a share block scheme, and the entered into connection with such a contract, and if any amendment or cession of such contract or agreement, it must be reduced in writing. So if you amend certain things, you know it must be in writing. Consumer agreements, you need to comply with the Consumer Act. That certain agreements must be in writing. Sale or lease or time sharing interest must be in writing. Credit agreements, be it like short or long, small or intermediate or long, it must also be in writing. Most of these agreements, the formality requirement that sets you apart is that it must be in writing. So there is also other contracts that can be affected by formalities. It's like long leases, mineral rights, where you need to deal with the Minister of, with the Department of Minerals and Energies, and then you also have like anti-nuptial agreements. An anti-nuptial agreement concluded between parties must be registered within 2 months after that agreement is concluded, or after 2 months after 2 months of the marriage being concluded. So if you guys get married today, then within 2 months of that marriage, that contract that was concluded, if it's not registered before the conclusion of marriage, it must be registered. Other than that, it will mean that you have not married with the ANC. It will mean that you have married in terms of community of property. So there is a certain formalities imposed by legislation. One of them is that the written requirement that it's like it must be written, and then also some agreements requires an initial and a signature on all the pages. And also formalities, it must be valid and enforceable, especially the electronic agreements. And then when we talk about electronic agreements, then we also talk about advanced electronic signatures that offer an acceptance that is between the parties, that it should, from the documents, it should be obvious that there was an offer and it was accepted and both parties signed it, and you need to append for certain agreements a advanced electronic signature. For certain types of agreements, like your small agreements, you would look at your just a normal electronic signature, still secured. But when it comes to long or large credit agreements or agreements in general, where it's sale, alienation of land, acquiring share blocks or amending those type of agreements, it should also have a advanced electronic signature attached to it so that they can verify who's the originator of that, what we call a data message. A data message can also be a contract. So a contract in electronic form can be data messages. What is a data message? And then you need to also look at the uniform rules of court, if you're in the High Court, or the Match Court rules to make it enforceable. So that is where one should be looking. And then obviously, when concluding these contracts, you need to also take cognizance of jurisdiction. So drafting of contracts, in the contract, you can already say that in the event that a dispute arises, we will follow the law of this country. If it's an international contract, if it's between two South African people, they can then look at where did the cause of action arise. If there's a breach, where did the breach arise? And what court will have jurisdiction to adjudicate upon this matter? Is it a magistrate's court? Is it a high court? Because of where the person registered place of business is principal place of business, where is an ordinary resident, or where the cause of action has arose. And that, looking at those types of things to determine jurisdiction, you'll have to look at Section 21 of the Superior Courts Act. And if it's a matter that falls within the ambit and scope of the Magistrates Court, you look at Sections 28 and 29 of the Magistrates Court Act to say, in terms of this person, this court will have jurisdiction. In terms of this cause of action, this court of law will have jurisdiction. And you need to know that courts of first instance is normally your lower courts and the high courts. Supreme Court of Appeal is never a court of first instance, so it's either a district court, a regional court, or a high court that will have jurisdiction to adjudicate upon the enforceability, legality of contracts, and you need to make sure that you meet that. So you'll have jurisdiction in respects of causes of action and jurisdiction in respects of persons. Obviously, there is some dissatisfaction that the court displays where people start consent to jurisdiction that will give the credit provider or service provider an unfair advantage. And that's the example that I made, where you actually go to Brandfort and say the court in Brandfort will have a jurisdiction in case there was a breach of a contractual term where the breach occurred in Cape Town. Why not go to one of the local courts in Cape Town or in KwaZulu-Natal? Why not go to Durban instead of going from where the breach occurred in Durban? The parties both are sitting in Durban, places of business is there, residential address is there, but you institute action in a court somewhere in the Northern Cape. So that is what one needs to look at, and then also look at the different types of laws applicable. Was there express choices? Was there tacit choices that one has to look? Also looking at the intention when the parties concluded the agreement. You need to make sure from conclusion or drafting, when you draft an agreement, that the intention of the parties is clear as to who shall and would have jurisdiction in this matter. And then you have different types of electronic contracts that is coming out in the form of data messages. It's your automated transactions where you have this voice person talking to you, and one needs to check if all of these contracts does align to the contracts, the NCA, the National Credit Act, as well as does these contracts give rise to a valid contract that there's essentialia, incidentalia, and naturalia that's enforceable and doesn't go against the grain of the Constitution and the Bill of Rights, and it is not seen as against what we are trying to do. So guys, I think for tonight, Tomorrow night, we will start on page 127 of your readers, where we will start dealing with the Bill of Rights, specifically looking at constitutionality and how it affects the drafting of contracts, which is constitutional of nature. So without further ado, I would say, guys, I will call that the end of our session.
Thank you, sir. Though you did not have the slides, but you managed to give us the stuff. Thank you so much. Bye.
Thank you very much.
Thank you. Bye. Have a nice evening.
Thank you.
Thank you.
Bye-bye.
Bye.
Thank
you.
you.
Thank you.
Thank you.
Bye-bye.
Thank you.
I call that the class for today. Sure.
Goodbye.
Okay, guys.
Just like that. Okay. End of session.